This is the second lecture, or part 2 of the week 11 lectures for administrative law in semester 3, 2014-2015. After studying this topic, you should be able to discuss and explain the importance of freedom of information legislation, the key principles of the Freedom of Information legislation, or Act, as it's still referred to in the federal sphere. In some states it goes by a different act, such as in New South Wales, where it's referred to as the Government Information Privacy and Protection Access Act. Should also be able to discuss and explain the legal right of access which exists under the Freedom of Information legislation, and be aware of and be able to identify exemptions, conditional exemptions and public interest factors under the Freedom of Information legislation. Between 1982 and 1992, all 6 Australian states and the Capital Territory enacted legislation entitled the Freedom of Information Act. In about 2013, the legislation changed names in New South Wales in what is now referred to as GIPA, or Government Information Protection, Privacy and Access Act. And in 2002, the Northern Territory brought in a Freedom of Information style legislation. The history of how these pieces of legislation and the rights they provide came about are set out for you in the notes. It was an interesting period in Australia's political and legal history, and one worth knowing, but one that won't be considered significant for the purposes of any assessment. The 2011 update to the Guide to the Freedom of Information Act 1982, which is published by the Office of the Australian Commissioner, explains that the democratic purpose of the Freedom of Information legislation in Australia is to confer a legal right on members of the public to access information held by the government. There is a public purpose behind that right, and the 4 primary purposes are that it provides a mechanism for individuals to see what information is held about them on government files and seek to correct information if they consider it wrong or misleading. It enhances the transparency and accountability of policy making, administrative decision making and government service delivery. It affects in principle, a better informed community who can participate more effectively in the democratic process. And 4, there is a greater recognition that information gathered by government at public expense is a national resource and should be made widely available, or more widely available, to the public to whom it belongs. The key principles behind the legislation are that all members of the public enjoy an equal right of access to government documents and are not required to explain their reasons for seeking access or to demonstrate a special need for or interest in a document. The right of access to a government document is a legal right. A government agency or minister has no residual discretion to deny access to documents upon request, and can do so only if a document is exempt by the Act, a matter which we'll come to later in this lecture and which you'll find referred to in the notes and in the Act, which you should have a look at personally. A person who is denied access to a document can appeal against the decision or agency to an independent tribunal, and in most states that is currently the various versions of the Civil and Administrative Tribunal, so in Queensland QCAT. The appeal is by way of merits review, so that a decision which is being made by the tribunal is a fresh determination and becomes binding on the relevant agency or minister. At all stages of the FOI processing and review process, an agency or minister bears the onus of establishing that their decision is justified. Agencies who publish information that explains their role and work, such as their decision-making powers, organisational structure, categories of documents, FOI procedures and policies, should assist in those early cases that you might get as practitioners in terms of understanding how the process works. An agency or minister may grant access to any document, even an exempt document, unless prevented by a secrecy provision. And we'll come to those shortly, and you can find them for yourselves in the Act. Section 11 of the FOI Act provides a legally enforceable right for every person to documents in the possession of agencies and ministers, and provides that every person has a legally enforceable right to access the documents, and this is not affected by any reasons that a person gives for wanting access or any belief that an agency might have about the reasons for seeking access. Now, it's important to remember that the right of access to documents in the possession of agencies and ministers is not absolute. There are categories of documents which are exempt. The exempt documents fall into three general categories: exemptions to protect the workings of government, exemptions to protect third-party interests, and exemptions to uphold other recognised legal interests. Whilst you don't necessarily need to be familiar with the inner workings of these exemptions, you need to understand that they exist. And just by way of example, exemptions to protect the workings of government tend to be protected in all proceedings in what's called public interest immunity. They're designed to ensure that information which is necessarily confidential or secret remain secret. Examples being national security, some law enforcement mechanisms, etc. Exemptions to protect third-party interest, for example, are privacy or commercial dealings. So if a government holds private information on you as part of an application process that you undertook before releasing it to some unrelated party who might simply be trying to look into your affairs, you have a right to object. Similarly, for example, regulators might hold information on the way that a certain business might undertake its work and is required to hold that information as part of an investigation or similar, and those sorts of documents would be protected from discovery by other businesses, perhaps competitors, who are simply seeking to use freedom of information legislation to gain access to a competitor's information. And exemptions to uphold other recognised legal interests would include, for example, legal professional privilege. So advice given to the government or one of its agents by lawyers for the purposes of either receiving a legal opinion or advice or undertaking litigation would be protected. Now, the exemptions take different, or the provisions which provide for the exemptions take on different constructions. Certain documents which are deemed conditionally exempt on the ground of public interest are still required to be provided or access provided, unless, in the circumstances, access to the document at that time would on balance be contrary to the public interest. And you can see there that that's a subjective value judgment that needs to be made by the particular officer processing a freedom of information application, and or a tribunal which is redetermining the request for access. And you can see there a list of the types of conditionally exempt documents, so Commonwealth state relations, financial or property interests of the Commonwealth, personal privacy, business and the economy, etc. Section 11B of the Act identifies the public interest factors that favour access and the irrelevant factors that must not be taken into account in deciding whether or not to provide access, and in doing so whether or not on balance it would be contrary to the public interest to do so. You'll see there that the promotion of the objects of Act as set out in sections 3 and 3A, which are contained in the notes, the questions of how the documents might inform debate on a matter of public importance or promote effective oversight of public expenditure, or allow a person to access his or her own personal records are considerations which favour granting access. Subsection 4 provides the factors which must not be taken into account in deciding whether or not to provide access, such as matters running to whether or not a document might result in embarrassment or loss of confidence in the government, or whether or not it might result in a person misinterpreting or misunderstanding the document, whether or not the document was or is of high seniority in an agency to which the request for access relates, or whether or not it might result in confusion or unnecessary debate. Now you can imagine that these factors were cited as irrelevant considerations because they were expected by policymakers who put the legislation together to be common ways for a bureaucrat to knock back a request for access to information which they thought might reflect adversely on the body politic concerned. These are matters to which you as future lawyers would need to turn your mind when assisting somebody, where it be the case in prosecuting a freedom of information application, most likely an appeal in a review tribunal. Now, Schedule 2, Part 1 of the Act contains a list of government agencies which, pursuant to Section 7, are deemed not to be prescribed authorities for the purposes of the Act and are exempt from the operation of it. You can see there, for example, the Australian Government Solicitor, who provides legal advice and legal representation to the Commonwealth Government. Each of the states, incidentally, have their own version of the Australian Government Solicitor, usually called something like the Crown Solicitor's Office. You'll see there that the security and intelligence organisations, so that is the Australian Secret Intelligence Service, the Australian Security Intelligence Organisation, the Office of National Assessment and the Inspector General of Intelligence and Security are all exempted, as are the Parliamentary Budget Office, which you can see broadly correlate with the conditional exemptions which we discussed a few minutes ago. That's an overview of freedom of information. There's more detail in the notes and again in the textbook, and you'll need to attend to that material once you've got a general overview of this particular topic. This lecture ends here.